Hi, this is David Bliven, Bronx and Westchester divorce attorney, with another episode of Lessons from the Divorce Wars. So this lesson comes about because I got a question from a potential client, and the potential client was asking me, what are the types of ways that I can kind of keep costs down? Because I'm kind of concerned that we may get into either long drawn out uncontested litigation or even contested litigation. So, kind of just a budgeting question. So, I get this question a lot, both from potential clients and clients. So, here's my response. One thing is, try as best as you can to settle the case. If you're on speaking terms, there's no domestic violence issues going on or coercion issues going on, speak to your spouse. Have the proverbial kitchen table discussion about how are we going to resolve the custody and visitation issues, the child support issues, the property and asset distribution issues, et cetera, et cetera. One of my favorite clients that I had, she came in to see me like 15 years ago. I still remember her name to this day. I could rattle it off in 2 seconds if this wasn't confidential. But she comes in for the initial consultation. She says, Mr. Bliven, we just need you to draw up the settlement agreement. My husband and I discussed all the basic terms of the settlement, and here they are. She handed me the bullet point list of everything they agreed on. And it was everything. It was comprehensive. So I drew up the settlement agreement, did the divorce, and, didn't take advantage of the situation, even though they were high net worth, high income people. They were so pleased that I didn't take advantage of the situation and I just did the job that they asked me to do. They referred other cases to me. So the other thing too is meet with your lawyer. Discuss settlement at the earliest possible opportunity and rediscuss that as the case is going along. I had a client he's spent at least $60,000-$70,000 on his divorce so far and had not discussed settlement with me throughout the entire contested litigation, despite me advising him to do so. He literally said, well, I want to see the disclosure first, then I want to see the depositions first, et cetera, et cetera. And there's not a lot there to proceed on this case. It doesn't warrant all this litigation, but he's just kind of steadfast on that. So just have that discussion with your attorney, especially if finances are an issue, which is the case with a lot of people nowadays. Another option that people have is whether they do net worth statements or not. It is always the recommended approach that you do them, but there's no hard and fast rule that you have to do them. For instance, if you're confident that you know what your spouse's income is, their assets, et cetera, then the two of you can specify that in a schedule that is simply attached to your settlement agreement, what each of you have, et cetera, et cetera. Again, not the recommended approach, but if money is an issue, you want to have that discussion with your attorney about whether it makes sense to do the net worth statements or not. Another option to get into the more contested litigation, there's the option of your attorney serving a demand for discovery and inspection, interrogatories, doing depositions. All those are recommended in most contested cases. However, again, no hard and fast rule that you have to do them. So if budgeting is an issue, you want to have a discussion with your attorney about whether, maybe instead of doing the demands for discovery and inspection, we just exchange the mandatory disclosure. Mandatory disclosure is in the preliminary conference order. It's the 3 years of tax returns, bank statements, retirement account statements, credit card statements. That's it. And again, if money is an issue, maybe you just want to stick to that. Not the recommended approach, but have that discussion with your attorney. Depositions, conservatively, if you have a good attorney representing you, between the preparation and doing the deposition, you're easily looking at $5,000 to $10,000. And if you don't have $5,000 or $10,000 burning a hole in your wallet, then you may want to have a discussion with your attorney before you even schedule that deposition about whether it makes sense in your case. And unfortunately, depositions are usually held at the end of your divorce case, after all paper disclosure has taken place, after you've had multiple court dates. And a lot of people, the well is starting to run dry at that point. So, you have to budget the deposition, but then you also have to have enough money to afford the trial. And trials cost $20,000, $30,000, $50,000, $100,000 to do. So you really want to have that discussion with your attorney about whether it makes sense to proceed in that fashion. Another option to keep costs down is gather the documents on your own. So, don't have your attorney or their staff pester you about, hey, where's the net worth statement? Hey, where's the financial documents that the other side is asking for, in terms of their demand for discovery and inspection or something along those lines. Gather all those documents, send them to your attorney. I always tell my clients, set up a Google Drive, set up a OneDrive, whatever, share the folder with me, and that allows my staff to simply download your documents right into my computer, and then I have my staff organize that. We set up a separate folder, and we then share it with opposing counsel. Done. Easy. Should be very easy. Shouldn't be complicated. And if you do most of that on your own, then you're going to save money that way. Likewise, if you hire a good attorney, guess what they're going to have? They're going to have staff. They're going to have a paralegal to assist you with things like that. So if you can't do it on your own, contact the attorney's paralegal. Don't contact the attorney. If you want to keep costs to a minimum, contact their paralegal and say, hey, I need help getting my net worth statement together. I need help getting the financial documents together. Please assist me. The paralegals are charging at least half, if not a third, of the hourly rates that the attorneys are charging. Again, money is an issue. You want to coordinate with staff as opposed to the attorney. Also, make sure that you have a discussion, especially if the attorney has associate attorneys that might be able to do certain aspects of your case. Have that discussion with your attorney about whether it makes sense to have the senior partner working on your case, or maybe have the associate attorney working on certain aspects of your case as well to keep money down to a minimum. So these are just some of the ways, definitely not an exclusive or exhaustive list, but some of the ways you can budget your case and keep costs to a relative minimum. If you are looking for similar answers to these types of questions, check out my blog. You'll find it at blivenlaw.net/blog. See you next time.